Everyone, we will call the Senate and House Judiciary Committee Conference Committee back to order. We were on a recess from last night to give the House an opportunity to review more thoroughly the Senate offer for the contents of Senate Bill 58, and we had passed out a document as well related to that. And so we will look for comments from the House.
Well, good morning, Madam Chair. Just some, I guess, general comments to start with, and then we may go back to Representative Ralph if you'd like. But as we've discussed this, we've not personally had any constituents reach out to us with concerns. I think I can speak for the three of us, have not had a single member on our floor come up to us and ask us to reopen up KEMA. And then last night, as we went back and forth and debated bills, I walked around our floor and I've visited with a wide scope of our members, our super conservative, our super liberal, and everything in between. And not a single member had any interest in us trying to rush through additional changes to KEMA. We're not hearing concerns that need to be addressed. We don't want to hastily make changes to this after we just passed it a few weeks ago, and we've not had time for the process to play out. You know, if things are not being handled correctly, if school districts are not handling their hearings the way they should, or if the court is issuing orders that they shouldn't be, there's a process in place, and that's what we do. We pass laws and we allow the process to work, and if it works its way up to the Supreme Court and they find out that something we have done is not what we intended, well, then we can come back and fix it. And so our general position is we are not interested in taking up this KEMA bill and would prefer to go back to our original idea of using the shell to insert the sexual assault kit that the KBI and law enforcement and others asked for. That's where we're at, and I think where we're going to continue to be at. If we want to go through your proposal, then I think Representative Ralph does still have a number of concerns that we can talk about concerns he has, and I think the rest of us on our side have, that if one were to consider making changes, concerns we have with the proposal that was made.
Thank you. I appreciate those conversations that you had in your chamber. I had some of the same conversations while your chamber was around last night, and heard other things, heard different things that, wow, when they became aware of how a particular instance of a court adopting some actually substantive changes to Senate Bill 40, they were quite concerned. When they have heard how some school boards are having hearings not in front of the elected body, but in front of a lawyer who's been hired by the district, they sure were concerned, Representative. And I would think that the body, the House, its 118 members who voted yes for Senate Bill 40 would be very vested in learning how it's being implemented and how it's affecting constituents, and that though the order from the court isn't necessarily in their district yet, would they be happy if the same order would come out in their district? Would you, the three of you in your districts, be concerned if the same order came forth and was to govern the procedure in the courts in your districts? I'm sorry, I can't hear you. Can you speak on the mic?
In response to your question, Madam Chair, no, I would not be at all concerned. Thank you.
Well, that's certainly a position to take, but we have substantive changes to statute that was broadly supported in both of our chambers. 118 representatives voted yes, 31 senators voted yes, both parties, and the governor signed it into law. I think that we all have a vested interest in making sure that it's implemented correctly. And you said, well, we need to have it rolled out and see what happens. Well, we've seen what happened, and it's an issue that the Senate would like to see addressed. We'll stand at ease for just a moment regarding some of your other concerns and your other statements. Thank you. Having known the House position now that you've stated this morning, we need to confer with our leadership and determine what direction the Senate is going to proceed and whether it's a different direction or where we're going to be. So with that, we both chambers are caucusing at 9 a.m. this morning, and then both chambers are on the floor at 10. Or I'm sorry, you're not you're not calendaring at 9?
I believe I haven't thought past 8:30, but they're telling me hold on a second. Let me check my phone. My phone will tell me what time I have to be somewhere.
Well, actually, you know, we do have a few minutes, and really what the bill does regarding Senate Bill 40, it fills in some of the holes that we're seeing filled in by others in a way that's not really the intent of Senate Bill 40. If we could, and really if we could just look at, if we have a few minutes, pages 1 through 5 of the bill that deal with Section 1. And then you'll see throughout the document it's kind of repetitive because Section 1 happens to be school boards. I think Section 2 is community colleges. Section 3 is counties. And it's kind of the same procedure throughout the bill. So if we could just have the thoughts of, I guess, Representative Ralph and the concerns, we would at least then know some of those and where we are as we look for what do we want to do.
Thank you, Madam Chair. Yeah, I'll shift back to that spot, and
On page 3.
Actually, you're talking about the first 5 pages, so
Right.
As I'm looking at my notes,
And if it's just general, it then would apply throughout, but the same way.
I'll start with I'm looking at the top of page 5, the item sub 6 that purports to indicate that all district court administrative orders issued prior to the effective date of this act shall be null and void. My question would be at this point is, how does the Senate picture that in relation to the directive in the Kansas Constitution in Article 3, Section 1, that the Supreme Court shall be in control of all administrative matters of the courts? How do you see that we make null and void administrative orders, as it says here, all district court administrative orders related to these procedures, that sweeping statement? How do you see that in conjunction with the Constitution?
Okay, so that's too broad, and okay, I understand the concern there. Do you have other concerns?
Yes.
Okay, go ahead.
Let's follow down. Let's jump back a page to page 4. There is what I'll call a new section 3 there that talks about some limitations that are proposed to be placed upon courts in their review process. Under subcapital C, the question would be, is the Senate by that provision intending to indicate that there is not a requirement of exhaustion of what I'll call administrative remedy at the board level or the commission level prior to bringing their concerns to the district court? That's how I read that. I'm wondering what the intention is from the Senate in placing that particular requirement or limitation on the district court.
Okay, we'll just hear all the concerns, and then we'll see where we are.
Is there, can you tell us at this point? Because it might be
sure.
helpful in the next conversation if we knew whether we placed so much emphasis on wanting to get that quick, immediate hearing and with the board, if we are now going to say, but we really don't care whether you take that opportunity to exercise that option of expressing that grievance to the board, you can go directly to the court, because if they don't have to make that statement to the court that they have even made that claim or participated in that hearing, we're not understanding the need for it.
The need for it is there's no requirement in SB 40 that they appear before any board prior to taking their grievance to court. In fact, when we were putting together SB 40, the House and the Senate were putting it together, it was suggested that the party aggrieved, the person aggrieved, would have to go in front of the board issuing the order first for relief, and then if they weren't satisfied with the relief there, then they would have access to the courts. And in fact, that was a provision that the Senate had, and it was struck down by the House, so it's not in Senate Bill 40. So it's not a requirement of Senate Bill 40 that you take prior steps other than going to the court. So the Senate position in subsection C is the Senate doesn't see that there's that requirement in SB 40, and this is a new requirement being put into place by at least one court interpreting Senate Bill 40.
Okay, and that's right. So it is the intention, the Senate's intention in this piece is to not require an exhaustion of any prior remedy before they go to court.
It's the Senate position that it's not a remedy to be exhausted. It's not an administrative remedy that they would have had an opportunity to use, that the aggrieved person would have had an opportunity to use. So there's nothing to exhaust because there's nothing available prior to the court hearing.
I thought that what we do in this section prior to that is we make the school board, in this instance, we make the school board an opportunity.
School boards and community college and things do have the requirement in Senate Bill 40 that you, the aggrieved person, appear before them. So it's not, if the question is, I see where you're coming from, Section C does not and is not intended to erase or eliminate that requirement. You still have to go before the governing body of the school district or the technical college or the community college before filing your petition in court. So if that's what Section C is intended by a court, that would be appropriate. If it's something else that you appear before a board when they institute the order, that would be a step too far. Is that clear? You still have to aggrieve under Senate Bill 40 to the school board, the technical college, the community college first, and then to the court.
Yeah, at this point, I suppose we've made our concern clear, and probably as far as we're going to get in regard to that clarification for the capital C. I did have a concern there in further sticking with the school board section under item 1. Apparently there's some concern about the specificity that's being required by some district courts when the matter comes before them. Does the Senate's position consider the fact that in the original Senate Bill 40, there were no provisions provided that once an aggrieved party had completed their time with the school board or the county commission or whatever, when they make their next filing with the district court, there were no provisions provided in there for what I'm going to call service or notice, either to a school board or to the county commission or a city commission, whoever's involved. There's no provision there that they be served or provided notice of the request for hearing in the district court. And so I view that was probably intentional on the Senate's part because we wanted to move this quickly into the court. But if they don't have notice to the other parties, then the idea that they can be adequately prepared to go into this 72-hour hearing is going to require that the district court have some latitude to require a certain level of information, or we're not going to have a hearing that amounts to providing any due process, if you will, to any of the parties if the court doesn't have some adequate notice of what it's intended to be dealing with on this short time frame. So if we want this to be a short time frame, then it would appear that we have to give some latitude to the courts to require some level of information being provided. So I guess the question from the House would be to the Senate, what concerns do you have about putting this on a short time frame, but not allowing the court, or for that matter, a school board or a county to have some information about what they are being asked to confront in this 72-hour hearing, which, as it's described in here, if we're counting weekends and legal holidays, you get a notice on Friday afternoon, it means you're in court Monday morning.
Thank you. Actually, if you got a notice Friday morning, or excuse me, Friday afternoon, you could be in court Monday afternoon, not Monday morning. And it was agreed upon by the House, the Senate, and the governor, 72 hours.
And I have no problem with the 72 hours. My point being is that in this, is the Senate considering the lack of ability of any of the parties to be prepared if we don't give the court some latitude of saying, this is the information that not only the court, but the parties are going to need to conduct an adequate hearing within that short time frame.
I'm not sure by what you mean, this information.
Any information.
Well, again, I don't know what you mean by this information. You have to state your name, you have to state why you feel aggrieved, and what is the concern of the Senate is what we're seeing, at least from a court. What you have to put in the petition is beyond the requirements of Senate Bill 40, and makes it more burdensome, to your point. We want to make it easy and quick and access for citizens, and that's not what we've at least seen out of a court, and that's the concern.
And that's the only point of my question. I don't mean to have the back and forth, but my concern is whether the parties, particularly since there are no provisions for notice of that hearing to a school district or to a county, a request for that hearing, to your point, could be filed on a Friday morning, and the school district may not ever have notice even of the hearing until
So
Monday.
your point would be if it's under the school section or the community college, give them notice too.
That would be one thing that would be
Yeah.
entirely appropriate, not to mention the court needs to know what it's going to be dealing with besides the name of the petitioner.
And that's not all that the petitioner would put in there, because that wouldn't get you as a petitioner where you need to go. So certainly things to think about. We do need to go to another meeting, and then let's stand in recess until, we will stand in recess till the first adjournment or the first recess of the second body. How's that? Thank you, everyone.